Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest is Bill Mitchell, and Bill is a certified public accountant who represents taxpayers in IRS collections, audits, and appeals, and the U.S. Tax Court. He has offices in Santa Cruz and San Jose, California. He has also been licensed to practice before the United States Tax Court since 1978. Bill graduated from Santa Clara University in 1962. After his service in the U.S. Army, he worked at the Internal Revenue Service from 1966 through 1971 and has worked in public accounting from 1971 to the present. And today, I've asked Bill to provide or tell us about the process for appeals and tax court litigation after a tax audit. So we're going to be covering highlights of a complex subject, and we want you to consult with a qualified tax advisor about your situation. This is not a do-it-yourself job, okay? So I guess that's number one and the last thing that we'll probably say. Bill, thanks again for joining me today.
Okay, and thank you again for inviting me.
Okay. So, we finished a tax audit, which is enough of a headache all by itself. But we don't agree with the IRS's proposed adjustments. What's the next step?
Well, the next step is to write a formal appeal to the appeals division of the service, and usually that comes about after the audit report by the service has been processed, and then you'll receive a letter. Many times now the letter will come right from the agent's desk saying you have 30 days to appeal this case, and the formal protest will be completed and sent right back to the examining agent, and they in turn will forward it to the appeals division. So.
Okay. So basically you write a letter that says we don't agree.
Well, that actually can be considered a protest that would be recognized by the service. However, I would recommend that it be more detailed and go to specifics. Especially now, there's a new procedure that the IRS has announced, or the appeals division has announced, on how they're going to handle cases. And essentially what they're saying is that the case has to be fully developed and all arguments and everything is there for a complete trail of everything for the appeals officer to make the decision. In the past, what would happen in comparison to that is that as the case went to appeals, if the appeals officer thought there were more issues that could be discussed, it would almost be like an additional audit. Supposedly under this new procedure, they're taking the thing as it's presented and going with that.
So you and I have been doing some audit reconsiderations lately. It sounds like we may be having more audit reconsiderations in light of this policy.
It could. It very well could. But we'll just have to see how this plays out. But generally, I mean, even with this new procedure in place, I think the appeals conduct of the case and procedures in the case will still be in the same format. They can consider everything and especially what's known as the hazards of litigation that a revenue agent cannot consider, and try and still settle this issue and keep it out of the tax courts.
Yeah. So my experiences at appeals, and I haven't had nearly as many as you have, but I felt that by the time that we got there, basically things were pretty clear about what we were talking about. So we would talk about issues, we would talk about hazards of litigation and so forth, and usually come to some sort of an agreement and finish the thing. I don't think well, I can tell you, I've never had a case, I don't think, that I had to take to tax court. Although I did have one that sort of was handled through an offer in compromise that somehow made it made it over there. Anyway, okay. So how does the process come about for the formal protest then?
Well, the audit at the agent level ends without an agreement, and so therefore the issues that are unagreed are the subject matter of the protest. And as I said, it's written in fairly formal form, and all the arguments should be presented, and that's pretty much it. I'm not trying to underplay it or overplay it, but you cover all your bases, and and you go forward with it.
So basically, you would make your arguments about, you know, why you think that the agent's position is incorrect, maybe citing cases and law. And
That's
such.
correct.
And,
That's correct.
Yeah.
And also sometimes you'll get into even perception issues. For example, you'll say, we presented all these logs of diaries and things that document a certain thing. The agent doesn't seem to think they're satisfactory. We do.
Mm-hmm.
Now you're at the appeals level. Possibly you're speaking to someone who's been with the service for 10 or 15 years, who has a little better balance on what would be acceptable if the case were to go forward into a tax court. Would a judge think that that was a reasonable thing? So you get into that area where the matter of what's reasonable and what's not reasonable can be a gray area, and that's where the appeals person can probably bring things into a conclusion.
Okay. So then what happens after the protest is sent to appeals?
Generally, you wait a period of time. It's the appeals officers, I believe, have a certain amount of time. I don't know what it is anymore, but they're to contact the tax representative, because a power of attorney will have accompanied the file, and generally they'll say, we have received your case, and we will be contacting you in the future to arrange a face-to-face appointment. And or sometimes you'll even have an appeals officer say, well, we can have a telephone conversation on this, or a telephone conference on such and such a day at such and such a time. And that depends upon where the case has been sent from, say, this area. And one of the things that's happening recently is that the service is somewhat undermanned. And so, for example, if I have a case that should have gone from the San Jose agent to the San Francisco appeals, but because of the work overload, the case went to, part of the audit went to Reno, and then from Reno, the appeals went to Denver. And I had
Could have gone skiing, Bill.
Well, you know, it's interesting, because that brings up a great point, because the appeals officer was, I guess, an older gentleman such as myself, and so when he said, well, how do you want to do this? And I said, well, I'd like to have a face-to-face. And he said, well, how's that going to work? And I said, well, there's a tax case called L.O. Parker Jr., and that case says that a taxpayer is entitled to have an appeals hearing at the IRS office nearest his location. And he said, Bill, I'll get back to you. So, and he was really a pleasant person to deal with. He gets back to me a day later. He says, Bill, he says, if you insist, then I will come to San Francisco. And I said, well, would that be a good thing for you? And he says, not really. And I said, okay, then we'll do it by phone. But the reason why, and it got to be a very satisfactory result in this case, but the reason why I hesitate to have audits done on the telephone is that you don't have a chance to put all the documents out on a table.
Right.
A face-to-face meeting, and it's almost like an overall atmosphere of the thing. Plus, on the phone, somebody can always say, hey, we're through, goodbye, and that's it. And so I, whenever possible, I recommend a face-to-face meeting. And the reason why the service is doing some of this is they have as I say, they're undermanned, and they also have another issue called sequestration, which limits their travel.
Yes.
So even in this area, if you have a case that goes to appeals, more than likely you're going to have to make a trip to San Francisco, as opposed to having the San Jose office be the place, which would be more convenient. But they just don't have the allotment from the budget to travel and this type of thing. So you have to kind of work through that.
Yeah. And unfortunately, things are going to get worse, not better. They just cut the budget for the IRS, and
Right.
So they have people that are retiring that they're not replacing, and
right. They have less individuals, and there's a greater workload, especially with the new Affordable Care Act, which is under their purview. So I guess Commissioner Koskinen in mid-year, when he came out with his Bill of Rights reinforcement of what taxpayers' entitlements are, he also mentioned to Congress that, you're asking us to do more work with less people, and he was. His comments to Congress were a little bit biting.
Well, I think that I can understand why. Right. I think I understand a little bit about why Congress has done what they've done to the IRS, but I think that they're shooting themselves in the foot. I mean, it's a little bit like a parent punishing themselves. Okay, we're not going to go to the movie tonight because you did such and such. Right. Instead of saying, you're staying home with the babysitter, I'm going to the movie.
Well, maybe the good news and bad news there is that there would probably be less audits.
Yeah.
But on the other hand, it could be that they will increase the letter audits and lessen the office audits and the field exams. And sometimes letter audits are really inadequate to do the examination, because you start getting a letter that says send us records, and all of a sudden you've got stacks and stacks of records, maybe 3 feet high, and you're saying, how in the world are we going to do this? You'll have to come look. Somebody's going to have to come examine these things, as opposed to using FedEx or somebody to get it to them.
Yeah. Well, it is a very difficult situation for the IRS and with the IRS right now. It's frustrating for us as practitioners, to even talk to somebody, or waiting for months and months to get a conclusion or have something done that's fairly simple. Like I said, I had a case that was done, and the report was issued, but it wasn't processed as far as reducing the bill for the taxpayer for many months afterwards. And so we were still fighting with collections, trying to get them to hold off, and responding to, like you said, correspondence from different places,
right?
And basically sending them the report saying there's no tax due, and then they're all saying, send a letter back. Well, you'll hear from us. It's going to be at least 30 days till you'll hear back from us, right?
Right.
And then you don't hear back from them for months. So anyway, it's pretty wild. But as a U.S. taxpayer who's not overly fond of the IRS and concerned about protecting my clients, on the other hand, I'm a U.S. citizen, and our government has to be funded somehow. Mm-hmm. The IRS is the agency that's responsible for collecting that money, and if they're not looking, then let's just say, while the cat's away, the mice will play, and the mice will definitely play. They will take advantage of what we would call ultra aggressive physicians and what have you, and if there's nobody there to take care of it, then it means that less money is going to come into the government.
Right. Right.
IRS agents pay for themselves many times over.
Yeah. Well, that's what the Commissioner Koskinen's comments were. He says, in what area of private industry do you cut your biggest revenue producer and think everything's going to come out all right?
It's crazy, absolutely insane. Okay, well, enough moralizing for now. We're having a good time here, though.
Okay.
Okay, so why would appeals decide any differently from the findings of the original examiner?
Well, they can consider, we mentioned this earlier, the hazards of litigation. And a good example is an evaluation case, for example, where the service is valued, or the agent at the agent level has said the value is so much on, for example, an intangible asset like goodwill. Mm-hmm. And as the case goes forward to appeals, and you have all the tax cases that you can look at where there's some doubt as to just what that value might be, the appeals officer, and I've had this experience where they'll say, well, look, the value at the agent was this, and if this thing goes to court, it's probably going to get knocked down anyway. So why don't we settle this case on a value of so much? And that's one of the ways that you can have the hazards of litigation come about. Another one is that where there's multiple issues, and they'll say, well, the services issue on point A is very strong. Point B, that could go either way based upon all the court decisions that we're seeing. And C is another situation, go either way. So they may say, okay, why don't we settle this just on point A as being an amount that the taxpayer is required to follow, and we will concede B and C. So that's another way the hazards of litigation enter into it.
And I think another thing, just fresh eyes, if you will. So, in other words, maybe you're having a disagreement with the agent, and like you said, the manager may not be so concerned with technical issues at this time. We're more concerned with workload, what have you. And so the appeals officer, when they see the issue, they may say, oh yeah, I can see your point here. Okay, I think we can agree on that. So so that can help. Okay, well, are there hazards connected with going to appeals?
Well, there are in the sense that, at least it's been my experience, and this may change now with the new appeals procedure, but the appellate officer can raise new issues, or has been known to raise new issues under the new procedure that came out in September of 2014. The procedure says it's unlikely that will happen. It doesn't say it won't. So we'll have to see how that works from practice as we go forward. But I would always have that caution that yeah, a new issue could be raised that wasn't previously discussed.
Okay. Are there glitches in the procedures that can arise between the original audit and the right to go to appeals?
I guess, yeah, in the audits, the letter situation, you can have that where there's so many things that happen in IRS letter audits where I have one situation right now where different service centers got involved in the responses to the letter audits, and on the same issue, on the same set of facts, one service center decided in 2 out of 3 years that a penalty should apply, and the other service center said the taxpayer is entitled to a refund. and so in that instance, I don't know if I'm doing the right thing or not, but I sent responses, and that's another thing. Every time you get a letter from the service, respond. You shouldn't just let things sit.
Right.
And so I don't know if I'm cutting my throat by that response, but I'm saying you're inconsistent. Get your act together, and they may come back and say, okay, you lose on all three. But my point is that if one service center saw it or responded that it was a favorable matter, then again, same facts, same legal arguments, it was decided. In the other two matters, I mean, I shouldn't say other two, same matter. We have an inconsistent treatment.
So can you see a taxpayer ever representing himself or herself at appeals?
No, just absolutely not. And one of the things that I do when I go to appeals is that some professionals would not agree with me on that. In fact, many may not, but I always think it's better to have the taxpayer attend the appeals conference as well.
Yeah, that's unusual.
Yeah, because, and the reason for that is that a lot of questions come up from the appellate officer about the history of the client and certain things, and rather than being a note taker and saying, I don't know, I'll get back to you on that. If the client's there, he can fill in a lot of the blanks. And I guess the caution is the client going to blurt something out that may cause a new gray area to rise? You can always sort of mediate or control that if you're in a position where I'm there with the client to make sure things stay in check. But again, that's why I do it, because I've had cases where for whatever reason the client, and this client was another CPA, couldn't attend, and all of a sudden I'm getting all these questions. So I got back to him and said, hey, why didn't you tell me this? Why didn't you tell me that? Because one of the things that the service does is that they'll get on the internet, and all of a sudden new issues can arise that, where did this come from? And all of a sudden you got to have answers to that.
That's a new, more recent development too. There, I don't think about that much, but yeah, people can get on the internet and other issues can happen. With this social media stuff and everything else, who knows what they could be looking at?
Well, they have access to many things. Like one of the questions recently was, where did the client get this car? You know, I mean, they have access to DMV and that type of thing.
Gosh.
So, it's something that you have to be wary of.
Yeah. Okay. Well, what if you can't resolve the matter with appeals?
Then you go into tax court, or you either fold your tent at that time and reluctantly say, hey, we're going to have to concede this case. And sometimes you get in a real dilemma of the tax that's being alleged as owed and what the professional fees are to try and rectify matters. And that's always a tough call. Yeah. And so if you're going for something that's, if the IRS says, hey, there's $10 million at stake here, then probably you're going to go to tax court because it will justify professional fees and that. But where you get into tough situations is where maybe, hey, the tax is $20,000, and if you're going to go to tax court, you're going to consume that. So yeah. It's even in the small tax case, it just can go like that. So
sort of don't sweat the small stuff.
Yeah, yeah. So.
So what's the difference between going to tax court and going to district court?
Tax court, you just say, hey, we disagree, and you don't have to do anything more than file a petition when a 90-day letter comes out. If you go to district court, you're going to get a jury trial, and you have to pay the tax in advance, whereas if you're going to tax court, you're not required to pay tax. The deficiency still sits there.
Mm-hmm. Okay. Who's licensed to practice in the tax court?
Attorneys and CPAs such as myself will pass the test in Washington, D.C. at the tax court, and that's pretty much it.
Okay. So how do you get the case to tax court?
If you've reached an impasse at appeals and can't get it resolved, then they send out a letter that gives you 90 days to file a petition with the tax court, and then you're off to the races, because then that's got to be a very formal document, and all of a sudden you're getting into issues about the form of the document that's submitted, as well as all the issues that are to be covered, so that you don't leave any stone unturned. So that's a real important document that goes in, and it's filed in paper form. And the reason why I mention that is because the tax court has thrown me a curveball, because everything from that point on is almost electronic filing, and I'm not the most electronic guy in the world. But the petition itself is still paper filed, and then you wait for a response or an answer from the regional counsel, and then the case is considered joined, and you go from there, which involves meeting with the IRS attorneys and having pre-trial meetings that could go on for some time before you actually are entering into an actual appearance in the tax court.
Okay, so maybe you could talk a little bit about the process and what happens after you file that petition and up to the time that you get a decision.
Okay, well, after you file the petition, you'll be contacted in this area by regional counsel from San Francisco, and they'll arrange for a meeting in the city, because again, we get into that matter of sequestration, and they're located in downtown San Francisco at 100 First Street. And the initial meetings are kind of cordial, hello, how are you, and getting a general feeling for it. There's also a meeting called the Brainerton Conference, and that can be held at that time as well if the agents or the regional counsel people are up to speed on it. But generally what they'll do is they'll wait, and you'll have what's called the Brainerton Conference, and it got that name from a tax case that said that the regional counsel and the taxpayers' representatives should cooperate in providing documents with each other and information to expedite matters, so that all the issues are laid out and made known. There's no surprises, that type of thing, so that when the case actually goes to trial, the issues are very well defined.
Okay. And after then you go to the trial, I guess.
Well, there's before the trial in one of these cases I had recently, that required several depositions from third parties and that type of thing, and that was an interesting case in that the service started down one path on the issue that they were pursuing, and then after depositions from third parties, they decided, wait a minute, we don't want to pursue the issue in that fashion any longer. We're going to go to an alternative issue. And you come at it all over again. And this particular case involved valuations where both the service and the taxpayer engaged professional valuation businesses to further get involved, and it got pretty unwieldy, and it was a long, drawn-out process from the time that we were at regional council starting those conferences in 2009, and the trial took place in January of 2014. While those conferences are going on, at some point, regional council will even propose we can settle this matter based on their hazards of litigation for a certain amount, or they'll also say, would you consider going back to appeals and reconsidering some of these issues that now are more fully developed.
Okay. So we're about out of time.
Uh-oh. I talked too long.
Anyway, so then we eventually get to a trial, and then the court makes a decision. How long do you have to wait before you get a decision after the trial?
All right. We had the trial in January of 2014, and we do not have a decision, because that's one of the things people always ask is, well, how'd you do? Well, you don't know, because after the trial, the judge asked for formal briefs, and that is a very tedious process and document, because your writings have to be the arguments, and they have to be supported almost sentence by trial transcripts, tax cases, regulations, rulings, code sections, and that usually is a process where, in this case we recently had, we fired the first salvo in our brief, then the regional counsel answered.
We're all out of time, Bill.
Okay.
So thank you so much.
Sorry.
Well, this is a big topic, folks.
Okay.
I hope you got some appreciation for this process. Again, you know, this is not something you do yourself. You go to an attorney, you get a representative like Bill to help you out. But we just wanted to introduce you to give you an idea of how it worked. We'll see you next time on Financial Insider Weekly.